First, because of what appears to be a mini trial. It's a word, rather, two words said by Congresswoman Luistro. But she was saying that she called it a mini trial to let the people understand what the hearing was all about, para maintindihan ng lay person kung ano yung kanilang ginagawa. But then she says, of course, what it is really, it's akin to a preliminary investigation. First question is, would you describe it as a mini trial, what happened during the first day of the hearing last March 25?
Well, you see, the proceedings before the committee should be a hearing preliminary to finding whether or not they should file an impeachment articles in the Senate against the respondent. It should not be a trial in the same way that the Senate will conduct a trial. Otherwise, they will be usurping on the exclusive power of the Senate to try impeachment cases. So the line between hearing and trial is a difficult line to demarcate. But one thing to keep in mind is that the committee has only 60 session days to finish its work. It has a fixed timeline, not very long. So it cannot really hold a real trial, whereas a trial in the Senate has no timeline. They're not giving any fixed period to finish the job. So 60 session days is indication that what they should do is just determine probable cause sufficient to make a report to the House whether or not to file an articles of impeachment or to dismiss the case.
But the word being the words mini trial has become some sort of a focus of attention because it's been described by some. I know that Attorney Jesus Fals has described it as that also. And as mentioned a while ago, the chairperson of the House Justice Committee. Gusto ko lang pong tanungin sa inyo, kung tawagin man pong itong mini trial, mali ho ba yun?
Hindi naman, pero palagay ko there's no such thing as a mini trial. It's either a trial or not a trial. You cannot have something in between because the trial is really reserved for the Senate. And what should be done here is really something very simple. In fact, the Supreme Court elucidated that a committee hearing should only determine three things. Number one, whether or not the grounds are those provided in the Constitution. Number two, whether or not there is sufficient evidence to support the grounds. And number three, whether or not all the members have provided copies of the complaint as well as the supporting evidence. So parang preliminary lang talaga, not a full dress hearing that should be reserved to the Senate.
Again, they call it akin to a preliminary investigation to find out probable
Yes.
cause. Justice, are you seeing the March 25 hearing as it happened with issuing subpoenas, ducis tecum, ad testificandum? Are those still hearings that you see? Are they following the right process, or has there been an overreach of any sort that you are seeing or you're concerned about?
So far, issuing subpoena to get necessary documents to support the complaint and possible recommendation for an articles, I think that's within the powers of the committee. But it borders already on a full dress trial, so it should not be very extensive. It's just to get the documents, make sure that they are read, available for the Senate to use, but not too much.
When is it too much, Justice?
Too
When
much,
will it be too much?
They will, that witness, for instance, they will summon the witness and then they'll put him in the stand like they are the Senate already, and that should not be done.
How should they, what kind of process should be followed during the second hearing come April 14, because from what we know, they had issued subpoenas, as mentioned a while ago, ducis tecum and ad testificandum. Ibig sabihin po, dokumento at tao. For example, si Ramil Madriaga po, si Ombudsman Boying Remulla, the SAL-ends of the Vice President, and many more. Marami pong matters that were completed during the first hearing. How do you foresee the hearings to happen so that it does not border or become an overreach and seem like a trial?
It depends, I think, on the character of the witnesses. For instance, Ombudsman Remulla said, I'm not going there. I'll just send the person who is in charge of keeping the SAL-ends. And that's correct, because it's not needed to testify on something. Just they need a document. They want to be sure that it's there in case the Senate needs it. So that's all right, subpoena it, and then it's there. But to go into the merits of the SAL-end, I think that's beyond the powers of the committee.
Does that mean, Justice, that when documents are submitted to the Committee on Justice, there would be possibly someone, for example, within the Office of the Ombudsman, that will certify that these are true copies, etc.?
Yes.
But what if they go into the meat of the SAL-end? For example, in 2020 something, the Vice President SAL-end reached so million. Pagdating po ng 2020, 8 years later, umakyat po yan ng so and so million. Would that be a mistake, or would that still be in accordance with their power in the House Justice Committee
That
when
will
holding
be
hearings?
bordering already on the work of the Senate. I think they should even do that without publicity. They can just examine it in a executive session, make sure that the grounds are sufficient for submission to the Senate. But they should not be the ones to expound on the discrepancies. That will be preempting the role of the Senate, in my opinion.
What if just reading it out? Would that be also an overreach? Let's say, basahin po nila, kasi dami po nilang hininging SAL-end 2007.
Yes.
I forget the exact years, but there's a period by which 3 years na hindi po kasama, because I believe the Vice President was not she was not a vice mayor or mayor at that time. But to just read it, kunwari po, 2020, 1 million, 2021, 5 million, 2022, 10 million, would that still be okay? Or dapat po hindi, submit lang and not read anything?
I guess a summary of the contents would be sufficient, rather than a detailed examination and exposition of the contents. So a very summary with the aim in view only of determining probable cause.
All right. Would that be that's a judgment call, Justice, hindi ho ba? I mean, that's a judgment call of the committee members, especially because they can ask questions, or should they be allowed to ask questions to any of the people that they subpoenaed? I mean, the reason they subpoenaed them was to be able to ask questions, but how far can they go?
You see, Pinky, in the origin of impeachment in England, it was a substitution to revolution, alternative to revolution. How do you remove a very powerful official who is abusive without violence? So this became a method to avoid revolution. In the United States, they adopted the same idea of impeachment in order to be a substitute for violence. According to Benjamin Franklin, before they used to assassinate the officials, now they just impeach them. So it's a substitute for violence. In the Philippines, it's becoming a substitute for teleserie. So it's becoming entertainment. So I think we should avoid that, avoid too much publicity, especially at the committee hearings. It's all right to publicize the Senate trial, but committee hearing, should be low-key.
What about the right of the people to know, Justice? The right of the people to information and to
Okay.
know.
Yeah. I think the right of the people should be more in the Senate when we have to balance the right of the people also and the right of the official. As you can see here, the respondent did not even participate because this is just a preliminary hearing. Whereas in the Senate, if it ever reaches the Senate, the official will have to participate in full. So if you have a situation here where you have a mini trial without participation of the defendant, that will be rather unfair to me.
Justice, so far, the other point, before I go to that point I wanted to make, the other reason the defense team didn't show up was that parang sinasabi nga, the hearing is improper because it's already pushing towards a mini trial. That's number one. We talked about that. And then number two is they were alleging that the hearing is already on a fishing expedition. Just to follow up on the subpoenas that were issued, did you see anything wrong with any of the subpoenas issued by the House Justice Committee?
But there's a limit to what they can subpoena. Essentially, they should not try to improve the evidence submitted by the complainants. They should examine what are the evidence submitted by the complainants. If they go beyond that, that's fishing expedition already. So it's incumbent on the complainants to submit this evidence rather than to use the powers of the Congress to gather evidence that they don't have.
So you agree with the defense team that this is almost akin to what is happening is a fishing expedition?
I think there is a point there because the evidence that is being sought does not come from the complainants. It is coming from the committee. That should not be the case.
Via the issuance of subpoenas.
Yeah,
All right.
I think that is questionable.
We'll be taking a very short break. We'll continue.
Evidence, present the evidence that they have, rather than be the ones to be instrumental in building the case, because that would be an inquisitorial way of proceedings, whereas we have an adversarial system where we let the parties prove their case. We don't the judge doesn't prove the case of the parties.
Do you think it was a good idea, Justice, that they didn't show up during the first hearing, the defense team and the VP?
It's a double-edged sword. The other thing, Pinky, is that they are complaining because they say the committee treated the complaint against the president differently from the way they are complaining.
The impeachment complaint?
There is a false assumption there that the proceedings against the president and impeachment against the vice president should be treated on equal footing. The Constitution doesn't do so. For the Constitution says when the president is on trial, the Chief Justice presides. But not when the vice president is on trial. So there's a difference. Why does the Constitution differentiate between the treatment of a president under impeachment and that of other officials? It's because the president is the one running the country. So there is greater need to see to it that it is harder to impeach the president. So the Chief Justice has to be the one to preside. Not so in the case of the other officials. So it's wrong to say, oh, you treated the president differently. You are treating it unconstitutional. The Constitution treats the president differently.
Yeah. So that's not a point you
That's
think
not
that
a
should
good-
even be raised.
That's not a good
Because
ground.
when it gets to the Senate,
Yes.
iba din po talaga ang the
Yes.
presiding justice will actually be the Chief Justice.
That's
if it's
right.
the president.
Yes,
Yeah.
only if it's the president. Same in the
Exactly.
U.S.
Pagka Vice President po, hindi
Yes.
naman po si Chief Justice. So, to your point, to my question earlier, sir, that was it a good idea? Sabi nga, it's a double-edged sword. if they show up, because a group of lawyers already questioned the proceedings before the Supreme Court, and likely lang so po, the defense team may do the same, question the proceedings before the Supreme Court. In a case like this, if the defense team plans to question this before the Supreme Court, would it be wise just not to really attend the succeeding hearings? Because after all, you might want to question this before the Supreme Court, and you do not want to, showing up would actually be allowing yourself to be under the jurisdiction of the Committee on Justice.
Well, the choice, what I notice, what the defense has been doing is filing submissions ad cautelam. It's always ad cautelam. So they're answering but not answering. So I'm afraid they might be convicted ad cautelam also. So there is a limit to what you can say. We participate, we don't participate completely. That has a double-edged result because, as Dean Santa Maria pointed out, that is a negative pregnant. A negative pregnant is a partial admission. You're saying that I did not hit him that way, but you're admitting that you hit him. So it's the same thing here. Ad cautelam, there's partial admission. So
Yes,
that's
but no.
dangerous. They should, I think, confront the issues squarely. That's why they're given due process. But they elect not at this stage to participate. That's all right, but at least in the Senate, if it reaches the Senate, they have to participate. Because that's where the really right to be heard has to be exercised.
Do you think so far that the Committee on Justice has been doing its job correctly, or that there is no abuse of any sort? I ask that, Justice, because of the ruling of the Supreme Court during the first impeachment case against the Vice President, where basically they cited the one-year bar rule and the lack of due process. So there were standards that needed to be met, etc. So just going back, they said they agreed on sufficiency in form, sufficiency in substance, grounds, and then nandito na po tayo sa hearings sa fourth stage. Do you agree in all four stages that they are doing right now?
Well, if you will examine the decision of the Supreme Court, first it said there has to be due process in all phases of impeachment, all. Then medyo umatras, saying that while we said that, having said that, the due process required in impeachment is sui generis, a class of its own. In other words, it's not exactly the same as in ordinary cases. So for example, they said in the resolution, when there is a hearing in the committee, it should be limited only to the finding out whether or not the grounds are sufficient, the evidence is strong enough, and then copies are provided. So, in other words, very limited ang role ng committee. What is important is the trial in the Senate and, of course, the action of the House in plenary. The drama now, it seems to me, is being focused in the committee. And perhaps the attempt, because they may feel that they don't have the votes in the Senate, they have the votes in the committee. They might try to expose all their evidence in the committee already, because the objective is not really to convict, because they know they don't have the votes, but to expose the Vice President. And that can be done, they think, in the committee level. So that, to me, is the agenda of the complainants.
And is that violative of any part of the Constitution or any rules of the House? I just want to read one because I was looking into, kasi Justice Nasanay po, well, ako doon sa sufficiency in form or sufficiency in substance, committee report, or the fast-track way
Yes.
of impeachment. In the 2019, sorry, in the 19th Congress rather, Section 7 of their rules state, I'll just read a portion of it. If the committee finds that sufficient grounds for impeachment exist, the committee shall conduct a hearing. The committee, through the chairperson, may limit the period of examination and cross-examination by members of the committee. In other words, it is written in their own rules, to which I will have to add the part where Article 11, Section 3 says the House of Representatives shall have the exclusive power to initiate all cases of impeachment. Sila din po yung dapat na magbabalangkas ng kanilang mga rules, hindi ho ba? So again, are they on the right track? Let's take out the agenda that you were
yes.
saying. But with the sufficiency in form, substance, ground, and now hearing, determining probable preliminary investigation for probable cause, are they on the right track?
Don't forget, Pinky, the last subsection, which says Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. So they can adopt rules. And they have adopted rules on how far the committee at that level can investigate. So that's all right, as long as they do not impede on, they do not invade the power of the Senate to try the case. And I think they are bordering on that because they are summoning witnesses, vital witnesses, and I think they plan to expose the whole testimony of this witness already in full, as if it's a full-dress trial, when it should be more on determining whether or not it has probable cause.
Should, for example, the case of Mr. Ramil Madriaga, should his affidavit suffice? Ganun na, pwede ho ba yun na lamang, hindi na siya kailangan ipatawag, and accept that as part of the evidence and rule on probable cause?
A little more siguro, identify it and say, do you confirm? That's it.
I see. Parang, para lang to certify na siya yun, siya gumawa nun, at katotohanan ang nakasaad dito sa aking affidavit. And I guess the same with the ombudsman, whoever shows up, this is the certified true copy. Follow up on that. Justice, what happens if in the SAL-Ns that are being asked, what if there's a missing SAL-N 1 year, 2 years, or 3 years that may have not been submitted or may have, I don't know, was lost along the way?
Yes, it's all right as long as they don't go beyond putting on record what is there, no? When you cross-examine and interpolate, that's already the job of the Senate. Just
So dapat walang cross-examination?
that's the problem. But, you know, it's very hard also to demarcate the line between hearing and trial. Because if this were a trial, it's already unconstitutional because the Chief Justice should be the one presiding.
And it's the Senate that has the sole power to, also to
In the case of
basically have the
Bongbong,
trial.
I mean, in the case of Bongbong, the Chief Justice should have been the one presiding already because the hearing is a trial. So they should not, in other words, limited. Hindi naman mini trial, is a full hearing rather than a mini trial.
Justice, one last question.
Full-scale hearing.
So so this has been questioned before the Supreme Court, the proceedings in the House. Do you think that the Supreme Court should, I don't know if the word is entertain it, rule on this, or should the Supreme Court allow the process just to proceed under the Constitution?
I think right now the Supreme Court should lay off. It has not really, kung abuse man hindi grave, hindi pa grabe. So pabayaan na muna because the Supreme Court should as much as possible not intervene in impeachment cases unless there is very serious violation or when the fabric of the nation is being threatened.
Retired Supreme Court Associate Justice Adolfo Ascuna, sir, always a pleasure, and I'm sure we'll be speaking again.
you.
Next hearing.